Suddenly I'm run over by a bus, or how to get things in order before the bus hits. Part 2, wills and powers of attorney. We will not be addressing financial abuse of seniors at this time. Note, this is not an estate or financial planning seminar. Also, although I'm a lawyer, I'm not acting as a lawyer in making this presentation. You should consult a lawyer and/or accountant for specifics on estate planning. And references to outside materials or sources are not an endorsement of any of same, but rather intended to be a starting point for your own research. Also, the text of this talk will be posted by the library online, as will the video. Legal documents, the essentials, powers of attorney and wills. Powers of attorney. There are 3 kinds available in Ontario: continuing power of attorney for property, non-continuing power of attorney for property, power of attorney for personal care. A continuing power of attorney for property is, simply put, a legal document giving someone the authority to act on behalf of another person in legal and/or financial matters. The person granted that power doesn't have to be a lawyer, and it can be granted to more than one person. This document usually does not deal with healthcare issues. That will be discussed separately. What can or cannot be done by the attorney depends on the draft of the power of attorney document. It can, for example, contain restrictions such as monetary limits or length of time it is operative. Having said that, the most common power of attorney, sometimes referred to as a general power of attorney, grants the attorney the right to act exactly as the person granting the power, namely to engage in banking, mortgage property, take on new debt, pay bills, sign tax returns, etc. What cannot be done under any power of attorney is to remake or change a grantor's will or create a new power of attorney. A non-continuing power of attorney for property is used for a period of time, say if you're going to be away for an extended period of time. It cannot be used if a person becomes mentally incapacitated. Power of attorney for personal care. If you become mentally incapable of making personal care decisions, someone else must make them for you. This person is called your substitute decision maker. The power of attorney for personal care empowers them to make decisions about your health care, medical treatment, diet, housing, clothing, hygiene, and safety. For some decisions, including those about your medical treatment, the law in Ontario says your doctor and other healthcare providers must get your substitute decision maker's consent before taking action. Making a power of attorney for personal care lets you choose a person you trust to be your substitute decision maker if you become mentally incapable in the future. Making a power of attorney for personal care is also a way to make sure your wishes about personal care decisions will be respected. It gives you a chance to say what you want and do not want. For example, you can state this in your power of attorney for personal care. Ontario law recognizes that your known wishes, expressed while mentally capable about your future care choices, will be binding on your attorney or other substitute decision makers, unless they are impossible to follow. Ontario law does not use the term living will. Sometimes people use the term advance directive to refer to a written statement of wishes about future care. The government of Ontario has an excellent website which gives more detailed explanation of these various documents and also has sample forms that can be used for these purposes. Although a lawyer is not required to draft these documents, legal advice to understand exactly what you're doing may be desirable. The link to the government site, which contains sample forms and instructions for execution, will be posted with the text of this talk. Caveats. One important legal limitation on all powers of attorney: they cannot be used once the grantor has passed away. So the day you go to the bank and try and deal with a deceased estate, you will find that the power of attorney is no longer valid. You should also be aware that some financial institutions may have policies which require their own particular form of power of attorney to be used for them to be considered effective. A power of attorney is not the same thing as a last will and testament. Your last will and testament covers the distribution of your property after you die and only takes effect upon your death. A power of attorney only applies while you're alive and ceases to be effective upon your death. Wills. A person's will is a written document that sets out the person's wishes about how their estate, their assets and liabilities should be taken care of and distributed after death. It takes effect when the person dies. So think of powers of attorney as covering the term during an individual's life and wills the disposition after death. It's common to use a lawyer to draw up your will to ensure it is both legal and takes into account any considerations related to the estate, such as tax. However, it's also possible to get access to draft forms of wills through various websites. If resorting to the internet for draft forms of wills, make sure they are drafted for your jurisdiction. Don't pull up Nebraska forms. And of course, all forms have their limitations. Some wills are more complex than others. The more complex, the greater the need to get legal assistance. For example, you own property in another country with its own law as around wills and disposition of property. France's law is not Canada's law. Just because you say something in a Canadian will doesn't mean it is going to govern foreign assets. Get a lawyer well versed in these matters to provide advice. Holograph wills. In Ontario, an individual may also create a wholly handwritten will, which is called a holograph will. Holograph wills are exempt from the statutory requirement that a will be witnessed by at least two people who each subscribe to the will in the presence of a testator. The law in Ontario provides a testator may make a valid will wholly by his or her own handwriting and signature, without formality and without the presence, attestation, or signature of a witness. The courts have required that holograph wills must reflect that the testator possessed the necessary intention that it be a fixed and final disposition upon death, and not merely some other expression of their wishes. Out and making a wholly handwritten will that they alone sign. Do bear in mind that rival claims to an estate under a holographic will can result in extensive litigation dealing with disputed claims after the fact. Now, some common sense advice. Get powers of attorney and get a will. Don't put these things off, and don't put off updating ones you may have had from a long time ago. Powers of attorney and a will do not need to await your endless analysis or fear of offending someone for making a poor decision. Make the best decision you can in the circumstances. These can always be changed by you. Always talk to whomever you wish to designate with a power of attorney or as an executor in advance. No surprises. Storage of powers of attorney and wills. Wills and powers of attorney are documents which will typically be required to be presented in their original form, namely the original signed document, not a photocopy. Some institutions will accept a notarially certified copy, a copy that has been verified by a notary as a true copy of the original after comparison with the original. Some will require the original document to be produced. Many people store these documents in a bank safety deposit box, which may have rights of joint access for your trusted advisor, but you should be aware that some financial institutions are hesitant to allow the exercise of these joint access rights when one of the joint owners is deceased. Check with your financial institution to determine their policy. If you do elect to use a safety deposit box, make sure the keys end up in your "suddenly I'm run over by a bus" file so that physical access is not a problem. If these valuable documents are being stored at home, consider getting a fire water-rated security box for obvious reasons. For powers of attorney and wills, it's also very often the case when using a law firm that the firm will offer to keep the originals in safekeeping. A word about joint bank accounts. The normal assumption is that a joint bank account comes with a right of survivorship. Namely, when one of the joint owners passes away, the other joint owner assumes sole ownership of the account. Unfortunately, there is some doubt whether these assets are part of the deceased estate or do they pass to the remaining joint owner. This can be an issue if the parties expected the joint account funds would be available for use to address the estate's immediate needs, such as paying bills or taxes. Do check with your financial institution as to their policy on joint bank accounts and survivorship. Thanks for listening, and after a brief pause, Ms. Krause to relocate, we will field your questions.